In a community property state, all property acquired during the marriage is presumed to be community property. As we learn in Estate of Bray, this means that some transfers of property can't be made unless both spouses consent. Walter and Belle Bray were married in 1919 in California, a community property state. 10 years into the couple's marriage, Walter started a food brokerage business and eventually hired Richard Bray, his son from a previous marriage, as an employee. Walter paid Richard a salary plus annual bonuses. In 1944, Walter opened a savings account and named Richard as joint tenant. Every year, Walter withdrew money from the business account and deposited it into the joint savings account. Richard knew the account existed, but he didn't know when Walter made deposits, nor did he know how much money was in the account. Walter also bought savings bonds jointly in his and Richard's names. Richard knew the savings bonds existed, but he didn't know their value. Walter kept the savings bonds and the savings account passbook in his possession until his death in 1960. Belle knew nothing about the bonds or the account until after Walter died. When the time came to probate Walter's estate, Richard argued that he was entitled to the account and the bonds as surviving joint tenant. Belle claimed that Walter had created both tenancies with community assets, without her consent, and without valuable consideration from Richard. Therefore, Belle asked the probate court to grant her 1/2 of the value of each. The probate court found for Richard, reasoning that by working in his father's business, he'd rendered valuable consideration in exchange for the account and the bonds. Belle appealed to the California Court of Appeal.